Each year, hundreds of thousands of North Carolinians rent houses, apartments, mobile homes, and other dwellings as their residences. For the first-time tenant and some veteran renters, this can be a confusing and somewhat unsettling experience. The more you know about the process of renting residential real estate, the better you will be able to protect your interests and carry out your responsibilities under your rental agreement. This video addresses important aspects of the rental process that generates many questions from tenants. Tenant security deposits and pet fees. Although this information focuses on security deposits, from your perspective as a tenant, it should also be useful to landlords, property managers, and rental agents. The North Carolina Tenant Security Deposit Act sets out the rights and responsibilities of residential tenants, landlords, and their agents regarding tenant security deposits. See NC General Statutes Sections 42-50 through 42-56. The Act applies to all residential properties except single rooms. The Act does not require landlords or their agents to collect security deposits, but they usually do in order to assure that they will be reimbursed if certain specified losses are caused by tenants. Landlords also frequently use the services of real estate agents to help them manage and rent their properties. These agents must be licensed by the North Carolina Real Estate Commission and, like the landlord, must comply with the Tenant Security Deposit Act as well as the NC Real Estate License Law and various rules adopted by the Real Estate Commission when renting the owner's properties. How much security deposit can a landlord charge? If your agreement with the landlord is to rent their property on a week-to-week basis, your deposit may not exceed the equivalent of 2 weeks' rent. If you're renting on a month-to-month basis, your deposit cannot be more than 1.5 months' rent. And if your rental period is greater than month-to-month, your deposit cannot be more than 2 months' rent. Can my landlord charge me a pet fee? Yes. In addition to the security deposit, your landlord may also charge you a non-refundable fee if you plan to keep a pet in the property or on the grounds. The pet fee can be any reasonable amount that the landlord wishes to charge if your pet damages the property. The landlord may also keep all or a portion of the security deposit as necessary to repair the damage, in addition to keeping the pet fee. What happens to my security deposit while I'm a tenant? To ensure that your security deposit is safe during the period of your tenancy, state law requires the landlord or property manager to keep it in a trust account. A trust account is simply a bank account designated as trust or escrow that does not contain any of the landlord's or broker's personal funds. The trust account must be maintained in a licensed and insured depository institution authorized in North Carolina. Within 30 days following the beginning of your lease term, the landlord or agent must notify you in writing where your security deposit has been placed. Typically, this notification is given in the lease. If your security deposit is moved to a different bank during your tenancy, you must be notified in writing of the new location. Are there any exceptions to the requirement that my security deposit be placed in a trust account? Yes, there is one exception. If the owner is managing their own property, or the property is being managed by an agent who has agreed for the owner to hold the deposits, the owner may post a bond to cover the security deposits. In such case, the landlord must 1. Notify you and the other tenants of the name of the insurance company providing the bond. 2. Purchase the bond from an insurance company licensed to do business in North Carolina. 3. Name you and the other tenants as payees under the bond. And 4. Assure that the amount of the bond is sufficient to cover all security deposits collected. However, this is uncommon, and most landlords deposit all security deposits in a financial institution. Can my security deposit be placed in an interest-bearing account? Yes, under certain conditions. If a real estate agent is managing property for the owner, they may place your deposit in an interest-bearing account only if they have your written permission and the written permission of the owner. If your lease authorizes the agent to place your security deposit in an interest-bearing account, the authorization in the lease must be stated in a clear and conspicuous manner. The interest may be paid to you, to the landlord, or to the agent, and depends upon your agreement with the landlord. If you still have questions about tenant security deposits, you are encouraged to contact your private attorney. You may call the NC Real Estate Commission's Regulatory Affairs Division at 919-719-9180 if a real estate broker or firm is managing the rental property, or the NC Department of Justice at 919-716-6000 if you are renting directly from an unlicensed landlord.